this counter. The fourth line, my lords, in the para.
This was highlighted by somebody. It's already underlined by us.
My instructions are that it is not, my lords. I will only take a minute, my lord, just to read it out. It says, hence, the contention of the petitioners to shortlist the candidates community category wise in the ratio of 1:50 by following the rule of reservation at screening level is not feasible. They clearly admit that it is not feasible, my lords. Therefore, their intention in bringing 29, my lords, is not to follow the rule of reservation, my lords. It is to dilute it. Whereas 55 clearly was in consonance with the rule of reservation, the statutory rules in force, my lords. Yes, my lords. Then another point, my lords, in their counter, in the same case, which they have adopted in all the cases, my lords, they have given a stepwise clarification as to how they would implement it, my lords. If I may just read that.
That was argued by Mr. Dhundi on the first day itself. 1, 2, 3 steps.
May I just supplement it in such case, my lords? What they would.
If you have serious impression that multiplication of argument, repetition of argument carries more weight, you can continue with that.
No, that is, my understanding was that there was just a point that I would like to highlight, my lords. That is the only, my endeavor is only that. That is all right, my lords. I would just take my lords to a judgment that my colleague had referred to, my lords. Inder Prakash, my lords. Yesterday the judgment was passed on, wherein it says, my lords, wherein the commission's role, my lords, is highlighted.
Yes,
I would only.
The judgment was cited yesterday.
Yesterday, my lords.
About PSC's role.
PSC's role, my lords. I would only highlight one specific point, my lords, wherein it says that the commission must lay down the procedure. The commission, however, must lay down the procedure strictly in consonance with statutory rules.
Yes,
it cannot take any action which per se would be violative of statutory rules or make the same inoperative for all intent and purport, my lords. I would only submit that.
Yesterday, I remember that.
I would only submit that GMS 55, as it originally was unamended, my lords, was in consonance with the statutory rules under the State and Subordinate Service rules, whereas 29 is not, my lords. It is in contravention. That is my only submission.
Anything else?
No, my lords.
Yes.
I'm grateful, my lords.
Anybody else wants to add anything?
Your Lordship.
Yes, Mr. Ashok, you are in party in
Yes.
person in matter.
Yes, your Lordship. Yes, your Lordship. I am a party in person in 23907 by 2024, my lord.
23907
by 2024, my lord. Item
Yes.
119.
Mr. Kumar, you must be hearing the arguments for last 2 days. Our request is not to repeat anything. We are ready to
Yes,
hear as
yes,
long
my
as
lord. Yes, my
you
lord.
want, but
I have not repeated any points which are covered earlier. I have not repeated, my lord. My lord, in G.0 29, as far as concerned, there is no mention about the word which is open merit. Actually, in G.0 55, it is following on duly following rule of reservation. But here in the case of G.0 29, here is nowhere mention about open merit on which it is followed. It creates an ambiguity, my lord.
yes.
As far as concerned, my lord, in the case, in the case of Supreme Court, Honorable Supreme Court judgment of Nelson Motis versus Union of India, it is held as follows, my lord. It is well settled that if the language of a statute is plain and unambiguous, it has to be given effect to irrespective of its consequences. My lord, my lord, this G.0 29 also republished in notification, my lord, and also it is a mandatory instruction. My lord, as per the judgment of my lord 158/11 of 2023, it is mentioned in para 13, my lord, page number 222, my lord, writ affidavit 2390. The mandatory instructions have force of law, my lord. That means the statute here is creates ambiguity, my lord. The
Kumar, Balaji was read out in extenso by the first council on the first day.
My lord, it is just citation. My lord, the main intention is the basic standard is necessary. The procedure which described in Balaji Padavat is not quite different with the G.0 29.
This has been argued by almost every council.
Okay, my lord. Okay,
including Mr.
But
including
here,
Mr.
okay, my lord.
Sudhir,
Yes, my lord.
Sudhir.
But here is basic standard is not set, my lord, as there is no minimum qualifying marks, my lord. My lord. My lord, and another thing, my lord, in the case of in para 16 of counter of it, my lord, TGPS, the respondent stated that the method which are following in Rajasthan as well as Jharkhand are as on par with G.0 29, my lord. But the difference is, my lord, there is some difference, my lord. The method that followed Rajasthan and the Jharkhand are not similar as G.0 29, my lord. My lord, kindly see the page number 71 of counter affidavit, my lord.
Paragraph number?
My lord, page number 71, my lord. Rajasthan state subordinate service rules, my lord.
Which counter you are referring to? This counter?
23907, my lord.
23907. 23907 counter of PSC.
Yes, my lord. My lord, in the rule number 15 of 2, my lord, the number of candidates to be admitted to the main examination will be 15 times to the total approximate number of vacancies to be filled in the year through the examination. But in the said range, all those candidates who say...
Mr. Shukumar, we are trying to lay our hands on the counter, relevant counter. Kindly hold on for a minute.
My lord, here in the case, all the persons who got the same last cutoff marks will be qualified for main examination.
Yes, which paragraph? Which page number 71?
Yes, my lord. Rule 5, sub rule 2, my lord. My lord, the number of candidates to be admitted to the main examination will be 15 times to the total approximate number of vacancies to be filled in the year through the examination. But in the said range, all those candidates who secure the same marks as may be fixed by the commission for any lower range will be admitted to the main examination. My lord, here the cutoff marks which are described by the Public Service Commission, the last marks who got all are qualified for main examination, my lord. But in the case of TGPSC, the last cutoff marks persons are not qualified, my lord. If any candidates of reserve candidates not adequately selected, then the cutoff should be decreased some level, my lord. The method following this Rajasthan method is quietly different with somewhat different with your G.0 my lord. Moreover, that here is if any person got to same marks, there will be a procedure mentioned in here, my lord. That's why that method is different, and also as well as this method is different, my lord.
That's all, Mr. Ashok Kumar.
My lord, my lord, the data given by TGPSC on mains attendance list, my lord. Kindly 14% Srinivas handed over to you, my lord, the list. Srinivas, please hand it over to the Honorable Judge.
What do you want to show?
The discrepancies, the inaccurate data. I have to explain, my lord, the data.
Like this across the board. This is not any statutory provision. If you wanted to rely on some document, you should have filed it in the petition.
My lord, I will file it along with my written submission, my lord.
You should have done it before hearing commences today.
Okay, my lord.
If this is a statutory provision, gazette notification, judgment, we will take across the board. But if something which has relation with facts of the case, we will not take like this.
Yes, my lord. Must obey, my lord. My lord, and another aspect is the G.0 is not published not placed in public domain, my lord, until 6th August 2024, my lord.
Yes.
It is yes, my lord. It is, and also it is not uploaded in a Telangana government website as well as the Telangana Gazetted website, my lord. My lord, it is clear by seeing the file name of the G.0, my lord. While whenever any person download it, after downloading it contains one file name, my lord. The file name itself describes the timestamp, my lord. The file name contains the timestamp. My lord, a timestamp will explain the date of my lord, on which date it is completed. And moreover, that my lord, the G.0 which published in Gazette notification has not completely, my lord. Some parts are missing, my lord. Some sentences are missing. That's why one cannot understand which the full text of G.0 is completely incorporated in G.0 or in this notification or not. It is not confirmed, my lord. Unless one person can see the G.0 copy physically, my lord. My lord, kindly see some difference points, my lord. The words are sentences, some sentences are missing, my lord.
Now everybody has filed it. It is the impugned one. Why should we compare all this? What is copy which some words are missing? Now full-fledged copy is before us. We will examine it and decide.
My lord, to understand the complete procedure, and there is moreover the procedure of state board merit is nowhere mentioned in G.0, my lord. Nowhere mentioned in the G.0, which is followed by the TGPSC, which is adopted by the TGPSC. Yes, as far as concerned, the group 1 posts are multi-zonal posts, my lord. They should be, the overall merit should be considered as taken as multi-zone wide merit as per multi-zone 1 and also for multi-zone 2. But here TGPSC followed the overall state merit, my lord, which is a clear-cut violation of local reservation, my lord, which presidential order, Telangana state presidential order, which is issued under the Article 371D of Indian Constitution, my lord. My lord, kindly see the page number 185 in writ affidavit, my lord, about multi-zone Telangana state presidential order issued in G.0 124, my lord, republished by page number 185 in writ affidavit 23907, my lord.
Yes.
My lord, para 5 subpara 1, my lord.
Please tell us from writ affidavit where you have taken ground that this G.0. 29 is contrary to this presidential order. Where is that ground before taking us to the presidential order? In your writ affidavit, where is the pleading about it?
Just a minute, my lord, I will show it, my lord.
Where have
My lord, in the page number 26, my lord, para 18.
Yes, kindly come to it. Kindly read it.
I further submit that the first respondent declared the results of the group of services preliminary test on July 17, 2024, provisionally admitting a total of 31,382 candidates to the mains examination based on statewide merit. This approach is not in accordance with G.0 MS 29 General Administration, nor is it other to the para 5 of sub-para 1 of Presidential Order 2018, dated August 13, 2018.
For a moment, you are not saying that G.0 is contrary to presidential order. On the contrary, you are saying that even G.0. 29 is not followed.
Yes, my lord. No, my lord.
Yes. Reading that G.0. 29 is contrary to presidential order.
Not my lord. It is the what is not mentioned in the G.0. 29, my lord. My intention is it is not mentioned in nowhere mentioned in statewide merit about in G.0. 29, my lord.
You are trying to take us to the presidential order. First of all, please tell us where is the pleading that G.0. 29 is contrary to the presidential order. Then only we will examine. Otherwise, we will not examine if there is no ground.
The implementation is contradiction, my lord.
Don't argue in vacuum. Please tell us where is the foundation in your petition.
My lord.
If there is a pleading, we will examine that. If there is no pleading, we will not enter into that.
My lord, multi-zone violations are different, my lord.
If petitions are there, those pleadings should be there in your petition. That these are the violations.
And also G.0. 29. G.0. 29 rule of presidential rule not connected, my lord. These are separate interconnected issues. My lord, G.0. 29 violate the rule of reservation. That's why I am not going to so far. And I am coming to the multi-zone violations, my lord.
Anything else, Mr. Ashok Kumar? Anything else?
Sir, multi-zone violations, my lord.
That you have already argued, for which there is no foundation. Yes, anything else?
My lord, another aspect is rule of reservations have community reservations are retained in non-local candidates, my lord. Other state candidates are retained in community reservation in their application forms, my lord.
That's
kindly see, which is against to the Article 16 of.
That has already been argued, that rule of reservation not followed. Everybody argued that. 2-3 senior counsels.
G.0. 29 has not created any.
They have argued, they have given written submission. Yesterday, Mr. Sudhir Kumar argued, he gave more than dozen points to us in writing. 17 in precise.
Yes, madam.
Yes, if there is a new point, we are ready to hear it as much as time is required.
Just
repetition, please.
My lord, 1 minute, my lord. 1 minute, my lord. My lord, G.0. 29 is given to the over-representation to the certain categories, my lord. It is the main.
It has also been argued that this 763 multiplied gives the benefit to only OC candidates, reserved are deprived. Mr. Madan Mohan argued by giving all data, prepared a chart.
Uh,
That's all.
G.0 matter is completed, my lord. Would you, my lord, kindly permit me to argue on multi-zone issue matter and as well as non-local gets
We will
reservation, my
permit
lord.
you provided you show what you are arguing that this G.0 29 is contrary to presidential order. You show
No,
the pleading
no,
will permit you to argue.
no, my lord, it is not a contrary to the presidential order, my lord.
That is what you
It is
argued.
not, what my intention is, it is not mentioned in G.0 29, madam. State-wide merit is also intention, madam. And also TGPSC committed the violations of presidential order, my lord, in its implementation.
Where is the ground? Where is the ground? And TGPSC's no order is under challenge before us. PSC's no order is under challenge before us. What is under
It
challenge
is
is
select,
rule and the G.0 29.
the G.0 29 is to follow on multi-zone wide, my lord. It is different, my lord. And as well as G.0 55 also, TGPSC has committed multi-zone violation, my lord. It is a separate to the G.0 29, my lord. Presidential order is different as well as G.0 29 is different, my lord. But the selection procedure is followed on the basing on the presidential order, my lord. But the TGPSC are not followed that such rules. The each multi-zone should be considered as a separate rule for recruitment, my lord. But it is considered as the whole state is considered, my lord. That is the violation.
Yes, that's all, Mr. Ashok Kumar. We'll hear somebody else if anybody else is ready. That's all. Mr. Ashok Kumar, we'll hear the other part.
Yes, my lord. I have heard, my lord. I want to bring some multi-zone violence issues to your kind notice.
There is no ground in your petition. Please show the ground, then we'll hear you. If there is a pleading, then only you can argue on that point, not from vacuum. Yes, we are switching over to the next council. You are not addressing us.
Okay.
Yes, we have already heard.
Is one point I want to make, madam.
You are not a party in this matter.
If you permit, sir, I implicated in this.
No, we have already heard one petitioner. That's sufficient. If somebody is already a petitioner, we will hear him. Yes. Anybody else wants to add anything on behalf of the petitioner? Yes. Who will start? Respondent?
I will commence.
Yes.
My lords, one small submission. They may conclude today, my lords. Learned senior is unwell and has retired. If my lords may allow, senior will reply on Monday, my lords.
I don't think tomorrow we'll be able to take it
Yes,
because
ma'am.
of Friday CRP matters.
Correct, my lords.
Yes.
Thank
Fact,
you.
I recall correctly, my friend said that they don't have any arguments to make and they passed on written arguments.
Reply to your
rejoinder-
submissions, my
His rejoinder submissions.
Yes, ma'am.
May it please, my lord. I'll just pass on, my lord, 5 contentions which we seek to rely on. I can't match Sudhir, my lord, so I have only 5 propositions.
Any particular WP on which you are
I'll argue the lead matter, 26038 of 24.
24?
Yes. 26038 of 24, one Mr. Sondhi argued. But though I would invite the attention of the Honorable Court to the counter filed in 28488 of 24. Lord, I appear for the PSC in all these matters, respond number 2. Lord, all the learned counsel, my Lord, who argued for the petitioners, none of them, my Lord, began their submissions by saying who the petitioners are, how are they aggrieved, in what manner they are even interested in G.0 29. My Lord, therefore, my first submission, my Lord, is that irrespective of what they have said, we'll go by their affidavits. Some of them mention that they have appeared, some of them don't even mention that aspect. It is a copy paste of, my Lord, the lead matter in the other matters. Therefore, my Lord, what we have done is we have prepared a small list, my Lord, which your Lordship will find at page 3 of the compilation which I have just now given.
Yes.
I have mentioned, my Lord, the writ petition number and the petitioner names. The Lordship may kindly note the hall ticket number assigned to each of them. This is the hall ticket number for preliminary examination. And, my Lord, whether they have failed or passed, my Lord, I have mentioned. For instance, Mr. Sudhir's clients, my Lord, petitioner 4 and 5, he has mentioned in his affidavit though, are qualified in fact. Though, my Lord, no explanation is offered as to why they still intend to challenge. And then in writ petition 28576, my Lord, petitioner Kiran Nagaram, my Lord, he also qualified. Similarly in 28488, one of them, my Lord, we don't have the data whether he appeared at all or not. How he is concerned, we don't know. That is 23775. This is the one Mr. Sondi argued. Then, my Lord, 26038, that is the lead matter. The petitioner, one of the petitioner qualified. So, my Lord, this is a case where we have petitioners who have participated and failed, majority of them. And, my Lord, 1, 2, 3, 4, 5, 6 of them, my Lord, have qualified. Out of 21 who are there before your Lordships for the mains. Therefore, my Lord, my first submission is that having participated in the selection process and having failed, my Lord, that is my contention, my Lord, to, my Lord, avoid writing, my Lord. Paragraph A is my contention at page 1. That is challenge after participation.
Yes.
Now, my Lord, the process of selection, G.0 29 was issued on 8/2/2024. The notification is 11 days later on 19/2/2024. Prelims was held on 9/6/2024. Results were declared on 7/7/24. My Lord, they knew pretty well, my Lord, even before the notification was issued as to the process of selection, as to how the selection is going to be done in accordance with G.0 29. Being well aware, my Lord, about the process, they participated. Some of them, my Lord, successful, which they are yet to answer as to in what manner they are aggrieved. Because in spite of the fact that they have passed, they are before the Honorable Court. Perhaps to get over this, my Lord, a challenge after participation.
When these petitions were filed, examination has not taken place.
No, my Lord. In fact, my Lord, Mr. Sudhir's clients filed, my Lord, they filed in November, after the mains.
No, but any petition, few petitions are filed which is before examination.
All of them are after a prelim exam only. After the declaration of
What
results
is
of
the date
prelims.
of preliminary examination?
Preliminary examination was held on 9/6/24. 9/6/2024. The results were declared on 7/7/24. The lead matter was filed on 18/9/24. Other matters were filed after that only. In fact, Mr. Sudhir filed in November, about 10 days ago, subject to what my friend would say. All of them filed after the declaration of results in prelims.
Yes.
Therefore, my Lord, my respectful submission on this aspect is that having participated in the selection process, knowing fully well the process of selection, and after becoming unsuccessful, my Lord, they are restored from challenging the selection process. For this proposition, my Lord, I rely upon the judgment of the Supreme Court in 2017, 4 SEC 357, which is annexed to my summary 8.
Yes.
May I invite your Lordship's kind attention to paragraph 13 at page 14.
Yes.
The law on the subject has been crystallized in several decisions of this court. In Chandraprakash Tiwari versus Shakuntala Shukla, this court laid down the principle that when a candidate appears at an examination without objection and is subsequently found to be not successful, a challenge to the process is precluded. The question of entertaining a petition challenging an examination would not arise where a candidate has appeared and participated. He or she cannot subsequently turn around and contend that the process was unfair or that there was a lacuna therein, merely because the result is not palatable.
Mr. Rajshekar, there are few petitioners who were successful.
Yes, my lord.
So petition at their behest will not be, this judgment will not help
It
you.
may not apply, but my lord, my respectful submission is this. In that case, my lord, they need to make out what's a grievance, which is not mentioned, my lord, in none of the affidavits. I can understand what's a grievance if you have qualified. If the people who did not qualify say that because of your pickup methodology I did not qualify, therefore I am before this court. But you knew what the pickup methodology is. And those who have qualified also, my lord, how can they say that because of your pickup methodology I am qualified? My lord, posing a question to myself. They have to have some grievance, my lord, for to maintain the writ petition itself. I understand, my lord, I have seen that. This judgment may not be applicable for those who succeeded, but question is, my lord, that they ought to, my lord, bring to your lordship's notice as to why are they before you? What is the ground they intend to take? This is where, my lord, what my friend Sudhir said, political reasons, my lord, comes in the way. None of the counsel argued. My friend Mr. Sudhir, my lord, stressed on the aspect that there is a change in the government. For political reasons, there is a fresh notification and all. A person who qualifies, my lord, comes to court. Something has to be read into it, my lord, is my respectful submission. My lord, second aspect is, my lord, the instructions, my lord, in the recruitment notification itself contain the process of selection. My lord, I will show you lordships. My contention would be that the instructions in the recruitment notification are mandatory in nature. They are binding both, my lord, the PSC as well as the candidates. And how the Supreme Court had viewed the instructions, my lord, because this is not a statutory rule or something. May I invite your lordship's kind attention to, my lord, the recruitment notification of the lead matter, which begins at page 43, my lord. That is Court of Garu 26038. Writ affidavit immandi.
Page number, volume.
My lord, volume 1, my lord, writ affidavit 26038, writ affidavit, page 57.
Page
57, my lord.
Yes.
This is where, my lord, para 12, procedure for selection at page 57, bottom is there.
Yes.
12.1, my lord. The procedure of selection will be as per G.0 55, General Administration Department 25, dated 25/4/22, and as amended by G.0 number 29, General Administration Department dated 8/2/24. There will be a preliminary test comprising general studies and mental ability. This test is meant for shortlisting number of candidates to be admitted to the written examination. The preliminary test will be conducted in English, Telugu, Urdu. B, my lord, the number of candidates to be admitted to the written examination would be 50 times to the total number of vacancies available in each multi-zone, provided that in case of any shortfall in respect of candidates in reserved categories, as laid down in Rules 22 and 22A of Telangana State and Subordinate Service Rules 1996, action shall be taken to include such number of candidates from the merit list beyond 1:50 ratio as required to meet the shortfall in the respective categories. Then, my lord, main examination, so and so, C and D. My lord, the provisions of GOMS number 29, which are in the nature of executive instructions, have may not attain the color of being mandatory in nature by virtue of they being placed in the recruitment notification. Now, my lord, then what would be the legality of such an instruction? My lord, for instance, if instructions to candidate, an innocuous instruction like, for instance, you please do not use pencil, please use only a pen. Let us say, my lord, that's the instruction. But Supreme Court said that even that is mandatory. You cannot say that what difference does it make? Now, I am using a pencil or I have used a whitener or I have did something else. My lord, there is a reason why, my lord, instructions are given to candidates and a methodology, my lord, is devised for the purpose of selection. My lord, the binding nature of instructions in a recruitment notification fell for consideration before Supreme Court. My lord, in 2020, volume 19 SEC, page 430, that, my lord, I have placed at page 17 of my compilation, which I have just now passed on. A case where, my lord, an advocate appeared for the my lord, recruitment to the post of civil judge in Telangana, Tamil Nadu State Judicial Service, where, my lord, kindly go to page 18, paragraph 1, my lord. The respondent, my lords got it, no? The respondent is an advocate enrolled in the Bar Council of Tamil Nadu. The Tamil Nadu Public Service Commission, for short commission, issued a notification dated 9/4/2018, inviting applications from eligible candidates for filling up 320 vacancies to the post of civil judges in the Tamil Nadu State Judicial Service. The respondent was successful in the preliminary examination conducted on 9/6/2018. The written test was conducted on 11/8/2018 and 12/8/2018. The results of the written test were announced on 19/8/2018 and the name of the respondent did not appear in the list of successful candidates. Thereafter, no interviews were conducted from 27/9/2018 to 5/10/2018 and the final results of successful candidates were published on 5/12/2018. My lord, the respondent, my lord, filed a writ petition saying that her name, my lord, is not there in the final selection list. The answer of the PSC was that she had violated a particular instruction. That instruction is extracted by the Honorable Supreme Court at page 19, plastum A. Penalty, that's the italic portion, penalty for violation of Commission's instruction in the descriptive type examination. The answer books of the applicant will be invalidated, marks deducted, debarred for violations of any one or more of the instructions besides initiating criminal action wherever necessary. There, my lord, usage of whitener, sketch pens, pencil, color pencils, multicolor pens, crayons or any other writing materials for any other purpose. This, my lord, it was argued before the Supreme Court that it is only a minor misdemeanor and that should not have a bearing. My lord, violation of this instruction should not have a bearing on depriving a person, my lord, employment, leading to violation of Article 21. Kindly see how the Supreme Court answered, my lord, at page 20, para 8. Yes. We have given our anxious consideration to the submissions made by the learned senior counsel for the respondent. The instructions issued by the Commission are mandatory, having the force of law, and they have to be strictly complied with. Strict adherence to the terms and conditions of the instructions is of paramount importance. The High Court, in exercise of power under Article 226 of the Constitution, cannot modify, relax the instructions issued by the Commission. Then 9, my lord. The High Court, after summoning and perusing the answer sheet, my lord, this may not be relevant. Kindly see 10, my lord. In spite of the finding that there was no adherence to the instructions, the High Court granted the relief, ignoring the mandatory nature of the instructions. It cannot be said that such exercise of discretion should be affirmed by us, especially when such direction is in the teeth of the instructions which are binding on the candidate taking the examinations. Therefore, my lord, in view of this authoritative pronouncement, which, my lord, is subsequently followed in several other judgments, this is the lead judgment, my lord, which is of the Supreme Court on this aspect. My lord, these instructions having attained, my lord, a mandatory force in view of they being included in the recruitment notification, and which the petitioners were well aware even before, my lord, they applied. Yes. Then, my lord, the question with respect to, because, my lord, the Public Service Commission has recommended, G.0. 29 itself says, my lord, that the recommendation was made by the PSC to the government on two counts. One is court cases, another is Balaji Badawat. Your lordship, my lord, had zeroed in on that. My lord, the state, my lord, came into existence on 2/6/2014. From then until now, my lord, there is no group and recruitment notification. Thanks to, my lord, a spate of litigations going on and on. My lord, whichever way the commission takes, my lord, whatever the commission does, my lord, there is always litigation, there is always a hurdle, my lord, unable to proceed further. Sometimes our own employees leak the papers, my lord, and then there is a litigation on that. My lord, several rounds, I will not go into all that. My lord, a batch of writ petitions came to be filed before this court challenging the validity of 55 itself. Where, my lord, they said that, look, 55 talks about following the general rules 22A of state and subordinate services 1996, which provides for reservation. You have no business to provide for reservation at prelim stage. You should provide reservation only at main stage, because prelims is only a screening test and the marks are not counted. Now, my lord, this is those bunch of cases are still pending. Lord. In spite of the fact that it has been amended, they are yet to come up for hearing before the learned single judge. My lord, now faced with this situation, my lord, the commission thought that there has to be an end to this litigation. Whichever way we go, my lord, something or other, my lord, is filed and it goes up to Supreme Court. In the end, my lord, it is becoming so difficult that it is now, my lord, we are in 10 years, my lord, since formation, unable to conduct even once. Therefore, my lord, by way of abundant caution, my lord, the PSC suggested that, my lord, there shall be an amendment to 55 by issuance of another executive instruction to ensure, my lord, that reserved meritorious candidates are given more opportunity, which I will demonstrate in a minute, my lord. And the only way we could do it was by following Balaji Badawat. A submission was made that why follow Balaji Badawat, which is 2009, why don't you follow Deependra Yadav, which is the latest one? Kindly note down, my lord, two dates. 29 was issued on 8/2/2024. Deependra Yadav was rendered on 1/5/2024. Deependra Yadav came subsequent to G.0. 29.
They are not saying that.
One, my lord, Mr. Ravichandra argued at the interlocutory stage.
He is not saying follow the penal. He is saying that principle is.
My lord, I remember pretty well, my lord, when he said, though, my lord, in final arguments nobody said that, at the interlocutory stage, Mr. Ravichandra, senior counsel, argued that if you want to rely upon some judgment, why not Deependra Yadav? Why only Balaji Badawat? That was the submission. But my answer to that is that Deependra Yadav came subsequently. Though, my lord, Deependra Yadav is a case where rules are amended after conduct of preliminary examination. My lords are well aware, my lord, the fact situation where after the conduct of preliminary examination on 27/1/2020, my lord, in February 2020, the state of Madhya Pradesh amended the rules. And then, my lord, those amended rules were sought to be implemented. Subsequently, after the conduct of exam, they were again withdrawn. My lord, that is the context in which Deependra Yadav landed up before the Supreme Court. There is no case here. One of the counsel, my lord, had argued that change of the rules after the game has begun is impermissible. There is no change of rule here at all, because the 29 is prior to issuance of notification. That is very clear. Therefore, my lord, the decision is on two aspects. One is the bunch of cases, and my lord, the counter filed by the TGPSC in one of those matters is relied upon to show that we have, my lord, sought to sustain 55. Your lordship wanted them to point out where we have said Balaji Badawat is not applicable. They could not point out. We didn't say that in so many words. I'll show, my lord, Balaji Badawat only one paragraph, we should settle the matter. And because of the fact that those cases were filed, we were constrained to recommend to the government, and government came up with this executive instruction. Now, my lord, my respectful submission is irrespective of how, my lord, the calculation is done, which I will show, my lord, which was placed on the website. One of the council ought to have brought to your lordship's notice. After the conduct of the mains examination, we published community-wise how many people from prelims got selected to mains and how many actually participated. They simply said, my lord, 209 into 50, 10,000 people from OC are participating. That was the argument, my lord, from Mr. Madan Mohan Rao also, my lord, said that. In fact, on 4th October 2024, we have published, my lord, which is there before your lordships. Kindly go there directly to page 4. This is the press note, my lord, published.
Page 4 of.
Page 4 of my compilation just now, which I have. Which would show the result of following 29. Kindly see, my lord, the total candidate attendance at page 4. Total number of candidates qualified for mains is 31,383. And then actual people who appeared for all the seven papers are 21,093. Then kindly come to page 5, my lord. The total attendance category wise, district wise is given, my lord. Then kindly come to category wise. Kindly see, my lord, candidates who are not covered by any reservation, Roman 3. Number of candidates who were picked up is only 3,076 as opposed to 10,000 or 15,000 which my friends are saying. Pausing here for a minute before we go to the other categories. 31,000 is the total number of people who are picked up from prelims to mains. People who are unreserved is 3,000, which is 28,000 people are from reserved category. Balaji Bhagawat in para 43 says if you compartmentalize them, they stand to lose. You cannot compartmentalize them. Please don't do that. If you have to do justice to them, if you have to do justice to reserved meritorious candidates, this is the methodology to be adopted now, which is very clear. We are before the Honorable Court right now showing as to how many people got selected. Now kindly see, only 3,076, which means the balance 28,000 is from reserved category candidates. We have given a category wise, my lord, who were picked up from prelims to mains. Same continues at page 6 also. As far as sports is concerned, my lord, there were some orders passed by the court. So about 20 candidates are picked up, my lord, with respect to sports category. That batch is pending. With every, my lord, every clause of the recruitment notification, there would be one dispute or another. But right now, just bringing to your lordship's notice that this is the factual situation. Kindly go to page 6, the actual number of people, my lord, who are picked up after serial number 10 in bold letters, 31,383. Actual number of people who appeared for all 7 papers is 21,075. So, my lord, in the affidavit, the petitioners, my lord, claim that more than 10,000 from, my lord, forward caste, the OC, that is unreserved, will take up, my lord, the places, which is unreal, demonstrably, which I have shown before your lordships right now. Therefore, my lord, in my respectful submission, operation of G.0. 29 is to the benefit of the reserved candidates and not as contended by them. So, first aspect is court cases, second aspect is Balaji Badawat. I invite your lordship's attention to that portion of Balaji Badawat. Kindly take up the volume filed by Mr. Aditya Sondi. Sir, yellow is fine.
Spiral binding, Mr. Raj.
Beg your lordship's pardon?
This spiral binding.
Yes, my lord. Mr. Sondi filed in the lead matter only.
Yes.
Balaji Badawat begins at 292. Kindly come to para 43. Prior thereto, there were two division bench judgments of our High Court. I think my friend Rahul will deal with them. Para 43, page 311 of this compilation. Para 43. 43, madam. 4343. Page 311 of this compilation. One other aspect of the matter.
Yes.
One other aspect of the matter must be kept in mind. If category-wise statement is prepared, as has been directed by the High Court, it may be detrimental to the interest of the meritorious candidates belonging to reserved categories. The reserved category candidates have two options. If they are meritorious enough to compete with the open category candidates, they are recruited in that category. The candidates below them would be considered for appointment in the reserved categories. This is now a well-settled principle of law as has been laid down by this court in several decisions. Then, my lord, all the decisions are referred to. My lord, taking a cue from para 43, an amendment, my lord, is recommended to G.0 55. As your lordship have rightly asked, which was not answered by any of the learned counsel for the petitioners, that show how are you aggrieved by this proviso. Juxtaposition is also shown. I will not trouble your lordship. Mr. Madan Mohan Rao showed your lordship a table showing the juxtaposition of 55 and 29 and how the proviso would read, and the lordship have very clearly seen that pick up first. Then if you find out that if any category is not represented, then go further down below and pick them up. Now the result is before your lordships right now, which I have passed on, which is placed in the web mail on 4/10/2024. Following 29 has inured to the benefit of reserved candidates. We have nothing against them. We want them to participate. It is for them to say why they are before this court in spite of qualifying. Then, my lord, the next submission, that is submission number 5, as I said, 5 submissions. Before I answer very briefly what the learned counsel argued. My lord, the writ petitions are filed with inordinate delay. In a matter of this nature, yes. My lord, the G.0 is dated 8/2/2024. The first writ petition lead matter is filed on 18/9/2024, 7 months after the G.0 was issued. Mr. Sondi, my lord, began his arguments by saying that in view of the earlier litigation, the Public Service Commission had no business to cancel it. They had no business to once again re-notify, because the direction of the learned single judge, as affirmed by the division bench SLP withdrawn by PSC, very clearly says you reconduct, and because of the fact that you took 2 years in the meanwhile and issued once again, large number of people who were earlier not qualified became qualified, and you could not have added more posts, 503 became 563. Well, these were the submissions my lord made. The lordship had also noted down, my friend Sudhir did not say anything to the contrary when the lordship specifically asked as to was this challenged. He said absolutely correct. Yes, it was challenged in a writ petition before a learned single judge. Unsuccessfully though. The learned single judge also put it, well, on the ground of delay, may pass on my lord copy of the judgment. Sorry. Thanks. Apart from the fact that they also challenged, my lord, some of the questions to which, my lord, they said questions were incorrect or the key supplied was also incorrect.
You just take us to the relief clause. Where was the challenge to the cancellation
It is, my lord, kindly come to the first page, my lord. First page of this, yes. Be pleased to call for the records relating to web note dated 19/2/2024, through which earlier notification number 4 dated 26/4/2022 was cancelled, and the consequential second notification number 2 of 24 dated 19/2/24, and set aside them as bad, illegal, unfair, unsustainable, unconstitutional, besides being contrary to public interest and contrary to the directions of this court in WP so and so. This is the earlier round of litigation, as affirmed by the division bench, and consequently direct the PSC to conduct fresh preliminary examination in persons to notification number 4 of 22 dated 26/4/24. Alternatively, declare that 503 vacancies notified in persons of first notification dated 26/4/22 be confined to those who have applied and participated in persons to the said notification, and consequently direct TGPSC to segregate 563 vacancies into 503 old vacancies and 60 new vacancies, and confer consideration separately based on their eligibility, by further holding the action of Public Service Commission in clubbing both old and new vacancies and expanding the competition by including ineligible candidates as bad and unconstitutional. Declare the extension of time by 2 days beyond 14/3/2024 to apply in persons to notification dated 19/3/2024. My lord, last date was 12th March. There was a glitch, my lord, in the bank payment portal. The candidates came before us and said, we are unable to make payment, you please grant us some extension of time. There is a glitch in your payment portal, then my lord, we extended by 2 days. That is found fault with. 3,000 more people have come within those 2 days. You ought not to have granted time for extension. That's also a challenge, my lord, in the writ petition by Public Service Commission, leading to unnecessary expansion of competition and aiding those did not apply within time at the cost of those who applied within time as bad, illegal, unsustainable. My friend Sudhir's prayer, my lord, most of the times runs into 2-3 pages. But my lord, it's a comprehensive writ petition challenging all aspects.
If you do too many illegalities, prayers will be like that.
He is happy with your appreciation. Yes.
My lord,
Obliged.
this
Sorry.
is dealt with by the learned single judge. Paragraph 9, my lord, at page 25. Paragraph 10, my lord, at page 26. After the chronology, my lord, of the prayer is extracted in this judgment, line about 4 from the top at page 27, my lord. First line at page 27. I'm sorry, my lord. Page 27. Thus, after a lapse of 6 months from the date of cancellation of old notification, this applies even now. The petitioners approached this court without assigning any reasons for delay, much less day-to-day delay. If the petitioners in WP so-and-so are really aggrieved by the cancellation of notification number 4 of 22, dated 26/4/22, through web note dated 19/2/24, they ought to have approached this court and challenged the same at the earliest point of time itself. Though the delay on the part of the petitioners appears to be only 6 months, but in a matter of this nature, the day-to-day delay matters. And further, the petitioners failed to explain even a single reason for the delay in approaching this court. Therefore, on this ground alone, this court is not inclined to entertain WP so-and-so without adverting to other grounds raised therein, except the objections raised by petition number 3 to the preliminary key. My lord, that we are not concerned. But my lord, though it was rejected, the question of delay applies to this case also. In fact, my friend Sudhir filed my lord writ petition in November. My lord, this judgment, my lord, was confirmed, by division bench, my lord, in writ appeals 1188 and 1190 of 24.
The so far notification dated 2/24 is concerned whether it was under challenge?
My lord, it is 4 of 22 and 2 of 24 is the current notification. 2 of 24 is the current notification.
No, it was challenged before single bench?
Yes, my lord.
2/24.
Yes, my lord. They said you have to set aside this. Kindly see, my lord. The very first page. And consequential second notification number 2 of 24 dated 19/2/24.
Yes.
The order of the learned single judge was confirmed in writ appeals, my lord. I've just passed on that. The division bench, my lord, felt that it would cause inconvenience to a large number of candidates who are waiting, my lord, in the wings for public employment for a long time. Ultimately, my lord, my lord, that is at page para 21, at page 22, penultimate page. If the main examinations are postponed, the candidates, my lord, Ashok Kumar, my lord, which I am relying on right now, my lord, is also relied upon by the division bench. My lord, that is challenge after participation. In that case also, my lord, the petitioners who got marks to a question which they claim is incorrectly framed, filed the petition saying question ought not to, he got the mark for that. And he challenges, my lord, the framing of the question before the learned single judge.
That's a different aspect.
No. It's similar to what is there before your lordships. A person who has passed is before your lordship. And in that context also, the division bench said, Ashok Kumar, which I have shown your lordships, that challenge after participation, then para 21.
Yes.
If the main examinations are postponed, the candidates who would be appearing will be put to irreparable loss, and that the administration has already taken steps and have made necessary arrangements to conduct the main examinations in a smooth way. And therefore, at this point of time, stalling the main examination would cause irreparable loss to scores of individuals, that too at the interest of 6 unsuccessful candidates. Same situation right now. My lord, SLP is preferred against this, which is listed tomorrow. Which is listed tomorrow, my lord. The SLP number. My lord, SLP 27790 of 24. 27790 of 24 and 27789 of 24.
All right, today's time is over. Tell us on Monday what happened
Yes.
to this SLP. See, the hearing resumed. You know, it's a batch matter. Hearing resumed. Shri Ashok Kumar party in person. Name of that girl, sister. Kiranmai. Kiranmai, है ना? And MS Kiranmai and WP number 28488 of 24. Appeared and concluded the argument. Dr. Shri Rajshekhar commenced his argument on behalf of for TPPSC, but could not conclude the same because of paucity of time. As agreed, list for final hearing as a part third matter on Monday.
Very well.
It will be first matter after motion.
My lords, item 126, my lords. So there is some urgency, my lords, may kindly take up next week, my lords, 126.
What is the urgency?
My lords, the status quo is pending since last 8.5 years, my lords, because of which the entire cadre of assistant section officers in the secretariats of both states is stalled, my lords. My lords, I have filed the implead petition along with the modification petition confining the
Court officer. 126 next week we'll consider.
obliged, my lords.
Yes, please.
I don't know, 135, where the railway ministry was supposed to finalize, 135 of 2024. 284 double eight of 24. Appeared and concluded the argument. Dr. Shri Rajshekhar commenced his argument on behalf of for TPPSC, but could not conclude the same because of paucity of time. As agreed, list for final hearing as a part third matter on Monday.
Yes, please. 4 weeks is too long a time. No, this is same matter, no, in which somewhere you said he's passed, somewhere you said he failed.
I am representing on behalf of petitioner.
No, we remember that case. No? In one P1 you were failed, P2 is passed, same matter. Tell us this side of the vacation, otherwise this will be next year. Tell us any time in the week commencing on 23rd. The parties to their council, item number
135.
135. Shri Mukherjee praised for and granted last chance to comply with the previous order as agreed list on 23rd December 24.
Obliged.
Yes.
Obliged.